So that's the privacy law framework in Canada and the latest international developments. I'm mindful of the time. So Judy, if I do go over, please let me know. I'm happy to stop and just take questions, but otherwise I'll keep going. And again, if I do have to stop, the presentation is available for anyone else to view through Judy. So the next topic I wanted to talk about is breach law, because that's becoming a prominent feature in the news within the last few years. So our federal private sector legislation for privacy says that personal information must be protected by security safeguards, including the use of encryption. Now, I self-servingly quoted myself here, but I'll condense this quote. The quote essentially says that if you outsource your data processing needs to another party, and that other party gets breached, you, as the data controller, are responsible, right? Actually, I should back up. There are two roles here, the data controller and the data processor. And the data controller is often the principal company that decides how data is handled. And if any of the processing of that data is outsourced, it'll be outsourced to a third-party data processor. And the idea is that if the data processor gets breached, the principal data controller is still liable. So in other words, the breach doesn't happen just to the data processor. The breach happens through the data processor, and liability can still flow to the original data controller. So there's an obvious need for due diligence controls to ensure that you've got the right data processor handling your data or your customer's data in the right way. And the first thing to do from a data protection standpoint, the very first step is to designate an officer responsible for privacy compliance. That is a principle in our federal private sector privacy legislation, and it's also mandated in the GDPR. So, there will be a trend of this position becoming more prominent. In Europe, they call it the DPO, the Data Protection Officer. Other names of that position are Chief Privacy Officer, the CPO, but they all go to the same thing. There has to be an officer responsible for privacy compliance within the company. The role of a data protection officer or chief privacy officer will be an important role going forward. The second step that needs to be done from a data protection standpoint is to perform a privacy impact assessment with respect to any personal data that could be within your organization's control, whether you have direct control of that data or indirect control of that data. The privacy impact assessment will help you determine what threats you need to control for, as well as what compliance obligations you need to control for. Okay, I've got a slide here on what the privacy officer should be doing with respect to the privacy impact assessment, but I'll move on just in the interest of time. Okay, and there's more data protection duties, of course, in the slideshow, and I'll move on again in the interest of time. Okay, so as of November 2018, in Canada, we now have, in the private sector, a breach reporting requirement and a breach record keeping requirement. So for 2 years after any breach is discovered, a private organization must keep records of all security breaches. Failure to report can result in a fine upwards of $100,000. Now, I could go on with this presentation, and I think I may already be over time. Judy, tell me if you want to cut me off. But before you do, I've got something important to say. It's in my book, not in the presentation, but this failure to report a breach that results in a fine of $100,000, that $100,000 limit is pretty tame. It should not be considered a ceiling, according to global privacy law trends. In the US, privacy law breaches are largely enforced by the Federal Trade Commission, which is the antitrust regulator down there. Just recently in Canada, we've had our antitrust regulator, called our Competition Bureau, take an active step against Facebook with respect to privacy non-compliance. And what I suspect going forward is that a breach can trigger this fine of $100,000 for failure to report, but it can also trigger fines grounded in antitrust law or competition law for much greater, potentially in the several millions to several tens of millions of dollars, depending on how egregious the breach is, how many people are affected, etc. So do expect going forward that a breach of your security safeguards will result in a significant fine and potentially also class actions, which we have been seeing more and more of in the recent past.